The 1-year grace period in patent law. Hi, I'm Derek Fahey, a registered patent attorney and trademark attorney with the Plus IP firm, and this is going to be a brief video about the 1-year grace period in patent law. So, by background, in patent law, it's all about filing earlier. Anything, all public information or information that's publicly available before your patent application will affect your ability to get a patent. So, in the US, we have what's called a 1-year grace period. The statute is 35 USC 102B. And that statute says that how if you disclose your invention, maybe to test for the commercial viability of the product for more than 1 year, then you can't get a patent. But if the disclosure, the public disclosure before you filed is within less than 1 year, you actually can still get a patent. And your disclosure, whether it's a sale or whether it was a presentation that you gave, that will not be considered prior art. And that's really important and helpful. Why? Because if you're trying to test your product and try to sell it on Instagram or TikTok or however you're trying to sell it, or potentially having a presentation or giving a presentation, you can do that, but you can only do it for less than 1 year if you're planning to file for a patent. So take, for example, you give a presentation about a certain software, you're testing or beta testing a software, and then you want to file for a patent application because it's a huge commercial success. Make sure you do it within 1 year. Now, you may be saying, well, what happens if somebody else actually takes my idea when I disclose it, and then all of a sudden your disclosure is being affected by this other reference that actually came directly or indirectly from you? Well, the 35 USC 102B actually has some exceptions that apply for that. The only problem with that is you're having to deal with those issues, and having to prove that that second person or that third party got the information from you. It's kind of a pain in the butt. Kind of don't want to be dealing with that, so it's best to have a non-disclosure agreement signed if you're going to be doing that, or try to file earlier rather than later. So you can still get a patent if you disclose your invention within 1 year, but it must be within 1 year. If you disclose your invention for more than 1 year, you're not going to be able to get a patent. And if you do, in litigation, potentially your patent can get invalidated if you disclose your invention for more than 1 year. So be careful when you disclose. Hopefully you found this video helpful. Leave any comments or questions to this video. Happy to answer them. You can find me online, derek@plusfirm.com. I'm happy to help. Instagram, Derek Fahey, PA, DEREK FAHEY PA. That's on Instagram. Same on TikTok. Happy to help. Looking forward to hearing from you soon. Please keep innovating. Have a great day.